Hello everyone, my alias is Amar Ahmed. I am a barrister and solicitor. I'm going to give you a free session on Canadian criminal law as an NCA subject. This syllabus has recently been changed, and you can see I have highlighted it. It says revise for June 2024. So there are a few cases which have been added. So I have highlighted those cases. The first new case is on in topic number 5, and that is mentioned at 5A of the syllabus. I have highlighted it, and then there are few more cases which have been highlighted with yellow. So this syllabus highlighted has been posted in our regular group on WhatsApp. So please have a look at it. There are not substantial major changes, but a few cases have been added. So the second case which you can find here is under the topic of provocation, topic number 20, and the case name is R versus Bra. So now I'm going to show you my material, which all of you have got access to that. Uh, this is called my brief notes. They are available on the website. So if you decide to purchase group tutoring, you will get my brief notes, which cover the whole NCA syllabus, and they are around, you can see 85 pages, and they cover briefly all the topics of the NCA criminal law syllabus, and the summaries of the cases have also been mentioned briefly in this document. For example, it starts from topic number 5A, which is actus rea. So this is document number 1. All of you must have it before attending the live classes. The second topic, which is posted on the website, is called Brief Summaries of Cases as per latest NCA syllabus. So it is a good handy document that it will give you a brief summary of all the cases mentioned in the syllabus. For example, if you have to discuss the topic of causation, which is 5D of the syllabus, or omission, which is 5E of the syllabus, or aiding and abetting, which is topic 9 of the syllabus. So all those cases have been combined together at one place. So this is a useful document. It can save your time. However, some members, they like to read from the detailed notes. So this is the brief summary of cases, but I have also prepared detailed summaries of the cases if you like to read from the detailed summaries. This document has been prepared from the publicly available sources like Hanley, like Supreme Court of Canada website. So this is for those members who like to read about the dissenting judgment, or they like to read, go into details. For example, these are the same topics like causation 5D, omission 5E, and then attempts topic 11. But this document is called detailed summaries of the cases, and it has summaries of all the cases. So you also will have access to that on my website. So far I have shown you three documents. One is called brief notes, second is called brief summaries, and the third is called detailed summaries. Now I have also prepared sample questions to practice in our regular tutoring session. This material is called Sample Questions on Canadian Criminal Law as an NCA subject. So these are hypothetically created problem questions or fact pattern questions. For example, let's have a quick look at few of the topics. One question is on sample question on criminal negligence, one then question on willful promotion of hatred, question on damage to property, question on robbery, question on possession, question on theft, question on bribery. So as advised earlier, these are just hypothetical questions for educational and academic purposes only. These are questions relating to the topic 5 of the NCA syllabus. This is how the scheme of my question is. So this is the topic of the question, on which topic the question is. This is the page number, and here it is mentioned topics of the NCA syllabus. For example, if you are looking for sample question on topic number 5, 6, and 7 of the NCA syllabus, so you know here is the list of those questions. For example, if you are looking for sample question on topic number 21. So topic number 21 in the NCA syllabus is a topic on entrapment, which is a defense in Canada. So you will come here. This is question number 29, but this is for the topic number 21. Likewise, if you are looking for a question on duress, which is one of the defense, then you will come here, and duress is topic number 19 of the NCA syllabus. So these are 32 problem-based questions or fact pattern questions. Then we have also prepared sample answers to those questions, and these answers are discussed in our regular tutoring sessions so that we have an idea that how to write the answers. Then additionally, there is an additional resource available on the website. These are 12 question and answers. So this is, for example, question number 1 is on theft. This is a sample question, and then this is the answer of that question. Then there is another question on question number 2 on obstructing justice. So this is the question, and then this is the answer of that question. Then question number 3 is on arson, and then below that would be the answer of that question. Again, these are hypothetically created questions just for educational purposes only. Now we are going to start discussion on one of the topics of the NCA, which is topic number 5 of the NCA syllabus. So let's have a look at this. So I was going to show you the sample answers of those questions as well. A few minutes before, I showed you some sample questions which we have created for educational and academic purposes only. These are the sample answers on those questions. For example, this is the sample answer on criminal negligence. This is sample answer on obstructing justice. This is sample answer on arson, which is one of the offense. Then sample answer on possession of property obtained by fraud. Sample answer on theft. Then answer on aiding and abetting. And then mental disorder is a defense mentioned in section 16 of the Criminal Code of Canada. This is a sample answer on that. And then this is answer on duress, provocation, entrapment. All these are defenses. So these answers are discussed in our regular tutoring sessions. Now, my dear friends, we are going to start discussion on one of the NCA syllabus topic, which is topic number 5 of the NCA syllabus. Topic number 5 of the NCA syllabus guides us that it starts with the discussion on actus rea. For any person, if Crown wants to prosecute any person who has been charged of any offense in Canada, Crown has to prove two things. Number one, that that person has committed the actus rea, which is mentioned in topic number 5, and then Crown also has to prove the mens rea of that person, and then mens rea discussion starts from topic number 6 of the NCA syllabus. I repeat, If Crown prosecutor has to convict or any person in Canada who has been charged, Crown has to prove two things. Actus rea of the accused, and actus rea is mentioned in topic number 5A, 5B, 5C, 5D, and 5E of the syllabus. So you have to see which one is applicable on your problem-based question. So in today's session, we will only discuss 5A of the syllabus. So there are certain requirements which needs to be met. Act must be act of the accused. So this is, and then secondly, act must also be the kind of act described in the relevant provision of the offense. And then thirdly, the act must be committed under the circumstances or conditions specified in the offense. I'm going to explain that point. These things have also been mentioned in my brief notes. All of you have got access to my brief notes. So this is on page number 2 of the NCA syllabus. So these four conditions must be fulfilled for an actus rea in your answer. So please apply them on the accused. Whenever, my dear friends, you read any fact pattern question or problem-based question, you have to look for these things and apply them on the accused. So whatever act is committed, that act must be committed by the accused. So if there are two accused in a problem situation, you have to determine which act has been committed by whom. The second requirement is act must be the kind of act described in relevant provision. Again, apply that on the fact pattern question. The act should be of the same kind which has been mentioned in the relevant provision. For example, um, if you want to determine in a question on theft or robbery or criminal negligence, that it should be the same kind of act which has been described in the relevant provisions. Relevant provisions here mean the Criminal Code of Canada's relevant section. The next one is act must be committed by the accused under the same circumstances or condition as specified in the offense. For example, every offense in Canada has certain conditions or certain circumstances. We call them statutory condition. So if Tom commits the act, the accused commits the act, but he does not commit under the same circumstances or condition as mentioned in the offense, then although an offense has been committed, but it has not been committed under the same circumstances or conditions mentioned in the offense. This is the most important requirement for if you want to charge any accused in Canada of the actus rea. So act may have been committed, but act has not been committed under the same circumstances or condition as specified in the offense. And then lastly, act of the accused must be willed and voluntary. So now let's do a practice of a question and it will give you an idea how to apply these conditions on the accused. Let's do a practice of a sample question and let's try to determine whether act of the accused has been committed under the same circumstances or conditions as mentioned in the offense. So again, the same document which has sample questions on Canadian criminal law, and then these are sample questions on different topics. They are around 32 questions. But also on the website, you might find some more question, but this is just one document. Let's do a practice of one question. So this is an section 219 of the Criminal Code of Canada. So let's first read the question and then apply section 219 with those same tests which we have read. This is a hypothetical question just for educational and academic purposes only. Chad, Tom, and David are on their way to watch a movie. All three of them are running 10 minutes late. Chad and David are in a rush. While crossing the walking signal, Chad and David saw Tom, who was on a wheelchair and was finding it hard to push his wheelchair. Tom asked for help from Chad and David. Chad does not help him in crossing the road and stops Davis from helping. Chad tells David not to worry about helping Tom, who was asking for the help, as they were late for the movie. A rash driver did not realize that Tom was still crossing the road and hit him. Tom could not survive. Question: can Chad be charged for criminal negligence under Section 2191A or under Section 2191B or of the Criminal Code? So we also have to see which subsection has been asked in any fact pattern or problem-based question. After reading this, then we also read now the section. I also advise my participants that it is helpful if we read the section first and then we read the question so that we know what actus rea we are looking for. This is an actual section from the criminal code. This says everyone is criminally negligent who in doing anything. Now doing here is the actus rea, or in omitting to do anything that is his duty. So omission here is the actus rea. And what kind of omission? Which should be your duty. So if something is not your duty, then you are not omitting that. It means you are not committing the actus rea. So in omitting to do anything that is his duty to do, shows wanton or reckless disregard for the lives or safety of other person. Now, what is the definition of duty? For the purpose of this section, duty mean duty imposed by law. Now, this is the actual section in the criminal code. Now, when you apply what we have read in our brief notes, that the act of Tom should be committed under the same circumstances or conditions as mentioned in the offense. So in this fact pattern question, the question is asking you, can Chad be charged for criminal negligence? If you remember the facts, Chad does not help Tom in crossing the road, and Tom was asking for help. So apparently, because Chad did not help Tom in crossing the road, and a rash driver did not realize that Tom was on wheelchair, and then he hit. So Tom got injury because of the rash driving of the driver, and also partly because Chad did not help him. So apparently it looks like that because Chad did not help him, so he may be charged of some. But when we apply this, it says in omitting to do anything, that is his duty. So when we apply that on this, do we think that it was the legal duty of Chad to help Tom in crossing the road? So most probably the answer is no. So although Chad ethically has committed something which he should not have done, but legally he was not legally bound to help Tom in crossing the road. So some kind of act has been committed, but the act has not been committed under the same circumstances or conditions as mentioned in the offense. And if you remember, that was the main thing I highlighted in my brief notes. I said you have to look for this thing, that whether the act has been committed under the same circumstances or conditioned as mentioned in the offense. And the offense here is 219. So Chad has committed some kind of act, but it is not the act as specified under the circumstances or condition as mentioned in the offense. So this is question number 1 on my website. Just for practice, we can do one more question and then we end the session. One more question is a question number 9 on theft. Let's read that question. Again, this is a hypothetical question just for educational and academic purposes only. And this question is also available on the website. The question says, this is a sample question on theft. Section 2322 says, everyone commits theft who fraudulently and without color of right takes, or fraudulently without color of right converts to his use. Now this is the actus rea. Fraudulently converts to his use is the actus rea, or to the use of another person. So you can also give it to some other person if the other requirement is met. This may also fall under the definition of theft. Anything, whether animate or inanimate with intent. So intent here is the mens rea. Then 1A subsection says to deprive temporarily or absolutely. So even if you deprive someone of his possession temporarily, you can still be charged under the offense of theft. To deprive temporarily or absolutely the owner of it or a person who has a special property or interest in it. Now let's read a question which is a problem-based question just for educational and academic purposes only. Tina and Amy are roommates in their late 20s who live in Calgary. Tina has an excellent collection of shoes, dresses, and coats. Amy, being a new immigrant to Canada, could not afford such a variety of fancy clothes. Tina went to England to visit her parents for the holiday season, and Amy had to attend an office holiday party. She selected Amy had to attend an office holiday party. She selected the best of Tina's attire and went to the party. Everyone really liked Amy's dress and shoes. Amy used them for 2 days. Amy used them for 2 occasions. Let's highlight that, for 2 occasions during the holiday season, and then cleaned them and then put them back. So Amy used those things and put them back in the same way as Tina would have, as Tina was returning in few days. Now, what is the summary of this? Tina used the dress, shoes, and tie of her friend Amy, who is not here. She used it on 2 occasions and then put them back. Now, currently, she does not have it. Now, can Amy be charged under theft? So let's see whether the act has been committed under the same circumstances or condition as mentioned in the offense or not. Let's apply it on Amy. Amy commits theft if Amy fraudulently and without color of right. So here the question tells us that Amy does not have a color of right. Amy did not think that this dress or coat or shoes, whatever, it belongs to her. She does not have a color of right. So she converts to her use. See here the actus rea. She converts to her use. She converts to her use. So when we apply that on the fact pattern question, we can see that she has converted to her use. But then she has put it back. 1A says of the same section to deprive temporarily. So clearly, Amy has deprived Tina temporarily of her dress, shoes, or coat, whatever she used. So although she put it back, but she has temporarily deprived her of her belongings. So in a way, the actus rea here has been committed under the same circumstances or conditions as mentioned in the offense. Also, she also has the intent. So the mens rea requirement is also met here, we can say. And then this can also be argued, although she put it back, and apparently she does not have it. But the subsection A says to deprive temporarily or absolutely the owner of it. Who was the owner? Tina was the owner. So Tina has been deprived temporarily of her possession. So in a way, actus rea has been committed. So that is, my dear friend, the end of this free session, which was only for educational and academic purposes only. You are allowed to share this session with any NCA candidate or foreign lawyer who is looking to qualify for NCA exam. If any one of you has any question, you are welcome to ask. I'm also going to show you that how to access my website or how to access the recordings and the materials and the practice question which is available on my website. So you will type in the Google NCA online teacher, and this website with the blue and yellow color, it will show up. So just type in the Google NCA online teacher and my website will show up. If you are visiting my website for the first time, then on the right side, you see register and sign in. Please have a look at it, register or sign in. If you are visiting for the first time, you will click register, enter your username, password, and then you will be able to purchase. If you are a returning candidate, then just click sign in, and then you will be able to see those courses which you have purchased. Here is an option to purchase group tutoring. We offer tutoring services for 13 NCA subjects. Here are the notes which have been prepared by Mr. Manuel Akinshola. And here are the recordings. And here is our services for Ontario Bar. So we provide services for Ontario Barrister exam, for Ontario Solicitor exam. So let's, for the sake of just to see that how the website looks like. So you will click on sign in, and then I will show you one course. So you will then scroll down and click access courses. Click access courses. Here it will show only those courses which you have already purchased. So because I'm the admin, I can see all the courses, but this session is for criminal law. So I'm going to show you the group tutoring Canadian criminal law. So here you can see group tutoring Canadian criminal law. Select on that, and then you will be able to see recordings and the materials and the practice question. So these are the recordings, the green one. Here I have detailed recording. You can see lesson 1, topic 5, A and B with 4 problem question. Lesson 2, topic 5, C, D and E, 3 problem question. So in many sessions, I discuss my problem question. Then lesson 3, topic 6, A, B and C of the syllabus with 4 problem question. So scroll down and then you can see how detailed the recordings are. There are around 16 lessons. Every lesson is around 2 hours, and this is like 32 hours of recording. And then if you scroll down, you see the green one. These are the recordings from the previous session. And then at the bottom of the page, you can see page 1 of 3, and then you will see further recordings. Scroll up, my dear friends, and then you will see materials and practice question. Let's click on that. And here you will see my sample question. So view full screen. You click on that, and then you will be able to see the sample question. This is my material, which you get as part of the group tutoring. So these are brief notes. This is brief summaries of the cases I have already shown you. This is detailed summaries of the cases I have already shown you. Then I have certain flow charts. So this flow chart is for automatism, which is a defense. This flow chart is for intoxication, which is another defense. This case is R.V. Brown. This is for the intoxication defense. This is a brief summary of that. So some of the cases which I find helpful and important, I have given summaries of that. So this is the summary of R.V. Stairs. These are charter right. This is bail section. This is the case R.V. Antake. This is a case used for bail section. This is an extra material for topic number 27, preliminary inquiry, topic number 28, jury trial. This is topic number 29 of the syllabus, pre-trial motion, topic 31, types of sentencing, text of section. These are the sections of the criminal code, and all these resources, they come as part of the group tutoring. Thank you everyone for watching this free recording. If you have any question, please send me a direct message either on Messenger or on Facebook. Thank you.